Just waiting for the last two people to join. All right, good morning for those of you joining from South Africa, and good afternoon to those of you joining from Australia and other parts of the world. Welcome to the August webinar at the Global Environmental Law Centre. We are really fortunate today to be hosting Professor Jolene Lin and Professor Jacqueline Peel, who are going to be speaking to us about their new book, Litigating Climate Change in the Global South. And I would just like to take a moment to introduce the speakers and just some house rules. So as you know, for the webinar, the speakers will present. They have around 20 to 25 minutes to present, and then questions will be held at the end. And you're more than welcome to post in the chat. All right, but without further ado then, Professor Jolene Lin is an associate professor at the Faculty of Law, National University of Singapore, and she's the director of the Asia Pacific Center for Environmental Law. She's a world-leading expert on climate change law, and her latest book with Professor Jacqueline Peel is the first systematic study of who, what, where, and how of climate litigations across Latin America, Africa, and Asia. Jolene is a member of the academic circle supporting the UN Special Rapporteur of the Right to Development and vice chair of the International Chamber of Commerce Global Environment and Energy Commission. Professor Jacqueline Peel is the professor at the Melbourne Law School and the director of the University of Melbourne's Multidisciplinary Climate Initiative at Melbourne's Climate Futures. She's a world-leading expert on international environmental law, climate law, and climate litigation. She has many publications, including this exciting publication with Professor Lin, and she is also served as a lead author on the Intergovernmental Panel on Climate Change Sixth Assessment Report for the IPCC. In 2025, Professor Peel will take up a prestigious Australian Research Council laureate fellowship for a program on international law and corporate climate accountability. We are really fortunate to have you today, and welcome. Thank you for joining us. And without wasting any further time, I'm going to give over to you.
Thank you very much, Angela, for the introduction and everyone joining online for the webinar. I'm Jackie Peel, and Jolene and I are here today both in Naarm, which is the local Indigenous word for Melbourne. So I'd like to begin by acknowledging that we're meeting on the unceded traditional lands of the Wurundjeri Wurrung people, and I pay my respects to their elders past and present, and extend that respect to any other Indigenous or First Nations peoples joining us on the webinar today. In this presentation, we're going to give you a sense of our new book, Litigating Climate Change in the Global South, which Angela's already introduced a little bit. We'll take turns going back and forth across the slides, and we really invite and welcome your questions at the end. So this book, as Angela mentioned, it's the first monograph that comprehensively analyses this phenomenon of climate litigation in the Global South, exploring the who, the what, the why, and the early impacts of Global South climate litigation. And we were keen to advance the idea that we need a broader understanding of climate litigation, not just one focused on northern jurisdictions, and also to understand better its links to international climate governance, given the massive task that remains ahead of us to address the climate crisis. We used interviews, social media analysis, and our own networks to uncover new cases and to analyse them. And neither Jolene nor I are Global South scholars, something that we make clear in the book. We're located in the Southern Hemisphere, but we're incredibly grateful to all of the wonderful litigators, practitioners, scholars we spoke to across countries in the Global South for offering generously their insights into this developing phenomenon. Some of the key questions that we tried to answer in the book were firstly why a study of Global South climate litigation was significant. And here we really wanted to point to the fact that a lot of climate litigation study and scholarship has had a global north focus, but there's been a very accelerated development of case law in the global south, and this was a worthy phenomenon to take into account in looking at the effects on broader international law and governance efforts. Within the context of a very broad set of countries that comprises the global south, we wanted to understand where such cases were particularly occurring, and Jolene will speak more to the jurisdictions that have particularly seen these cases and why we think it's concentrated in those jurisdictions. The book also tackles the question of what is encompassed by climate change litigation. We realise that this is quite well-travelled area in the scholarship, but again, just defining how we're understanding climate change litigation and looking at questions of how climate change litigation is defined and whether that has had a sort of northern flavour to it and needs to be changed to take a broader lens on the kinds of climate cases that emerge in global south countries. A lot of the book is dedicated to looking at the avenues by which climate litigation in the global south occurs, and we made some findings about the typical kinds of legal avenues and arguments that are made across global south countries. So even despite the diversity in the countries involved, there are some commonalities across how that litigation is being brought. Also, we saw commonalities in the question of who the actors are involved in litigating climate change in these countries and the roles that they play. And one of the areas that we particularly looked at that's a bit different is the role of groups like philanthropy and funders who are particularly involved in some of this litigation. And the final question is then the sort of what then, or the what does it matter question. What are the emerging impacts of this case law? How do they differ potentially from the sorts of impacts we're seeing from cases being brought in the global north? Just to give a flavour of the sorts of things we're talking about in terms of global south climate change litigation, we'll talk through a few examples. Some of these are no doubt very, very familiar. Litigating and Pakistan, the decisions in 2015, for example, have been the focus of a lot of scholarship already. This case is a really good illustrator of some of the kinds of considerations that we see coming forward in a lot of cases across global south countries. Namely, that it's a case less about trying to raise the ambition of climate law in that particular country, but saying that there are in place already national climate change policies and asking for those to be properly implemented. And using a line of argument based on fundamental rights to life, to dignity of person, to privacy of the home, and right to property, which in the case of Pakistan are protected as constitutional rights. Another aspect here was that the Lahore High Court in the initial decision ruled that the government failure to implement climate change policy in that case offended fundamental rights like the right to life, and included within that the idea that that right encompasses the right to a healthy and clean environment. And this feature of focusing on constitutional rights has been quite consistent across a lot of the climate litigation in global south countries, including some of the important cases being brought in South Africa. The judge, Mansour Ali Shah, defined or talked about climate change in this case as a defining issue of our time, and particularly grounded the decision in constitutionalism and international environmental law principles like sustainable development and precautionary principle, which again is a different kind of broader approach to understanding the legal basis for these cases than we sometimes see in the global north. The remedies that we saw in Litigating against Pakistan also show a lot of innovation in terms of the kinds of things that the court ordered, directing government agencies to actually nominate a focal person to work closely with the Ministry of Climate Change to implement actions required under the strategy. Establishing an expert climate change commission to assist the court in monitoring progress. And in 2018, in a follow-up, the court and the commission agreed that the remaining items on the commission's agenda could be implemented by the government, with the commission eventually dissolved. So it's quite a novel remedy that was crafted by the court that we also don't see in many global north cases, but this kind of innovation seems to be much more common in some jurisdictions across the global south.
That's right. So thank you very much for the opportunity for us to share this, to share our book with you. I'm going to take over from this part, and as Jackie has mentioned, we're going to be taking turns, one of the privileges of being in the same space. So a type of case that we do not include in the so-called global south docket are these transnational cases. But I do think it's interesting to think about these cases because that is and I think would be an interesting area for further development. I wanted to share that with you. I'm actually going to, so the example that we would talk about is another well-known case, Luya and RWE, and I'm going to speak quite quickly about it because it's such a well-known case. Luya is a Peruvian farmer whose property is in a place called Juarez, sits under a glacial lake in the Peruvian Andes. And RWE is one of the largest energy companies in Germany. Now, in this case, the concern was that climate change had caused increased flood risks. And the case basically relies on German nuisance laws. And basically, the lawyer is bringing a case against RWE, arguing that RWE has caused nuisance or harm to his property through RWE's contribution to climate change, and seeks contribution to the cost of increasing the flood defenses for his home. Now, what is interesting about this case is that due to developments in climate science and climate attribution science, we are able to the litigant here was able to argue that RWE had caused 0.47% of global post-industrial revolution carbon emissions. So Luya is basically suing for that proportion of the cost of preventing floods. Now, should the case be successful, it would demonstrate for the first time that major carbon companies or major fossil fuel companies can be sued for compensation for the climate harm they have caused. At the moment, the court decision is on an evidentiary issue is expected in a later part of this year. And the key question for the court is, does the risk of flooding pass the legal threshold to amount to a breach of German nuisance law? I'm not going to be talking much about this case, but it's a case that is really has the same case theory as Luya and RWE. In this case, similar, four islanders from the country Indonesia are bringing a case against a company in Switzerland, one of the largest constructions material companies in the world. And again, they're using this idea of proportionate liability to underpin its case. So here I'm going to pass it back to Jackie, who's going to talk about why we decided to write this book.
So with those examples in mind, we were looking both at climate change cases that were emerging in global south countries, and that's really the focus of the book. And part of the reason that we decided to write the book was that we felt there was a real gap in the academic discourse, particularly the Western English literature on climate litigation. So our initial intuition or hypothesis was that climate lawsuits were being filed outside the kind of northern jurisdictions that we hear a lot about, my own jurisdiction of Australia, the US, Europe, and so on. but were not being picked up by the media or by academics. And so there was sort of an invisibility to the developments that were occurring. We also thought that part of the reason that climate litigation in developing countries of the Global South might not be being picked up was because the lens that we were using to view climate litigation might be a bit skewed to global north. In particular, because climate litigation cases in developing countries do not generally bear the typical characteristics of climate lawsuits in the global north. We started to explore these ideas initially in an article that we published in the American Journal of International Law, Transnational Climate Litigation, the Contribution of the Global South. And at that time, we found 34 cases across the global databases and through our own knowledge networks and research that fitted this category of cases that were saying something meaningful about climate change and occurring in global South countries. By the time we got to the publication of the book, when we sort of drew a line under the number of cases we were going to include, we'd got up to 128 cases. So that just shows you in that period of time, really of less than 5 years, the enormous growth in the number of cases. So this really gave us a sense that this was an important phenomenon to be tracking in this book. So tremendous growth in climate litigation generally over that period, but particularly in the Global South in this period between 2019 and mid-2023, which is when we kind of cut off research for the book. We also saw a lot of improvement in our data collection over that period, our ability through networks, social media and interviews to track a lot more cases. And part of this has been because there are increasingly dense collaborative networks that are starting to give rise to what can be described as a global climate litigation community. And that now extends to many scholars, litigators, grassroots groups across Global South countries. As Jolene highlighted, that 128 cases does not include the growing number of cases that are transnational. So the Holcim case or the Lua case, where there's a case filed in a northern jurisdiction by a multi-actor coalition often that challenges a fossil fuel or other climate intensive project in another country, a Global South country. And it also doesn't include cases in international tribunals. So it's just the body of cases that are occurring in domestic courts in Global South countries. So to tell us a bit more about where climate litigation is happening, I'll turn back to Jolene.
So as you can see from the screen, we've found cases occurring in several countries across Asia, Africa, and Latin America. And the countries that are highlighted red are what we describe as the front-runner jurisdictions. Basically, we did 3 detailed case studies on these 3 countries, India, South Africa, and Brazil, because in each of these geographical regions, these 3 countries were where the highest number of climate cases were filed and decided. Now, what we see is that the term Global South is very all-encompassing, it's over-inclusive. What we see is that climate litigation is really happening in middle-income countries. Here, these countries are facing very significant challenges of maintaining economic development, tackling inequality, and where there are a lot of environmental issues to tackle. But at the same time, there are institutions that are good enough to encourage citizens to go to the courts to seek a remedy, and there is trust that the legal system can do something to address climate justice. As mentioned, we talk about the Global South docket as really looking at the cases happening in these 3 areas. And as you can see, Latin America and the Caribbean, you have about 66 cases. In Asia, 46 cases. And in Africa, we've registered 16 cases. Now, I'm not going to be talking much about the methodology. The only thing to mention here is that we exclude what we term incidental cases. Incidental cases are cases where climate change is mentioned only incidentally or in passing, without direct or indirect engagement in the plaintiff's arguments or in the judicial decision. And do we include cases where we know they are being motivated or there's the motive to use for these cases to change the law or policy on climate change, but where they don't mention climate change in the submissions or the judgment? And the short answer is no. For methodological reasons, we chose to exclude those cases. We coded the cases for 6 variables. We were interested to know who were filing the cases, who were being sued. We're interested in knowing whether climate change was a core issue or was one of the number of issues being litigated, such cases being referred to as periphery cases. We were interested to know what kind of legal avenues were being pursued. For example, the public trust doctrine, and whether rights-based arguments were relied upon, and finally, whether the Paris Agreement or national climate legislation provided a basis for arguments. As you can see, just because the sample size is quite small, the numbers fall quite evenly. But you can see that, interestingly, for Africa, the 4 cases would be 6 of them, and 10 cases would be at the periphery. When it comes to rights-based litigation, as has been discussed quite widely, there has been a significant rise in climate litigation relying on rights arguments, whether it's human rights or constitutional rights. And here we registered that there is, in fact, a significant number of cases. So if you look at this chart, the gray area being reliance on rights-based arguments and the yellow being non-rights-based arguments, for example, environmental impact assessment, you would see that all 3 areas, there is there are more rights-based cases than not. So one of our chapters really tries to sketch out and look at the whole landscape of climate litigation in the Global South, and to answer the question, who are the actors in this space? And we were interested in asking this question because, well, nobody has really actually answered the question, so why not? Let's try. So what we focused on was 6 actors who we found were playing a significant role in the space. About 3/4 of all the litigation being registered under the Global South docket were being brought by NGOs, and that's not surprising. We also found that in 2 unique jurisdictions of Indonesia, Brazil, and China, prosecutors and regulatory agencies were playing a significant role in litigating on climate change. And then, of course, the one significant actor has been youth. Youth-led climate litigation has been a significant trend. And of course, indigenous peoples, indigenous peoples is a group where they have addressed climate change together with other long-standing issues such as land rights and the right to free and prior informed consent. Here, I will talk a little bit about a typology that we developed in order to kind of understand the different modes of climate litigation that were unfolding in the Global South. And these were just terms that we developed because we thought they helped to capture what these actors were trying to do. So like now I'll just speak to 1 or 2 examples. So we had 5: the grassroots activist, the hero litigator, the farmer, the engineer, and the enforcer. Many of the NGOs would fit the modality of the grassroots activists. Many of the NGOs, apart from the big global NGOs like Greenpeace, were actually small grassroots organizations that were bringing litigation through public interest litigation. when we talked about the farmer, we were interested in looking at how some actors were interested in seeding cases in the global south and somehow replicating successful strategies that may have been seen elsewhere. And therefore, the idea of the farmer trying to cultivate and seed new cases in the hope of advancing climate litigation in the global south jurisdictions. Well, as to be expected, when asked what are the conditions that support the emergence of climate litigation, the conditions basically are the conditions that support the rule of law, of environmental rule of law. So first, access to justice. So in countries which had more liberal standing rules, we are more likely to see the emergence of climate litigation than in jurisdictions when standing rules have been very narrow, particularly to entities that seek to represent the public interest. Another condition is having judiciaries that are willing to hear arguments that use existing environmental and natural resources laws as the basis for climate change cases. Of course, it's helpful to have the relevant climate change and environmental laws. This provide the legal stock or the hooks for bringing cases. And finally, well, actually not finally, but the next constitutional protection of the environment has been an important factor. In many of the cases, we see that either there is the right to a healthy environment or the equivalent and constitutionally protected, or we have the right the right to life interpreted judicially as encompassing the right to live in a healthy environment. And that hasn't been important in the climate jurisprudence in the global south. And of course, having an active civil society that supports the litigation as well as the use of litigation as part of a broader advocacy strategy to advance climate justice. There are three things that we identified as key characteristics of climate change litigation in the global south. First is the idea that in the global south, climate docket, the litigation docket, we see a prevalence of rights-based claims. And this is because many constitutions in the global south jurisdictions contain environmental rights and the right to life that is interpreted to include the right to a healthy environment, as I've just previously mentioned. Secondly, we're not seeing a lot of the kind of what has been described as ambition cases in the global north, where plaintiffs are bringing cases to seek more ambitious action by the government on climate mitigation, usually. Instead, what we see in the global south is that there is a strong preference for enforcement of laws and policies that already exist, rather than pushing for new or more ambitious climate laws. We talk about climate litigation in the global south as adopting a stealthy mode. We describe it as a mode where litigants are actually advancing cautiously and quietly by packaging climate change issues with others, less politically contentious claims. And this might be because, well, I think, recently in a workshop that Jackie had in a few days ago, I think that the term that comes to mind, which I thought was really appropriate, is smart litigation. You basically tailor the litigation strategy to suit the circumstances of that particular legal system or jurisdiction. And in countries where there are traditions of judicial constraint or limited judicial review, then a stealthy climate litigation strategy is, well, strategic. So on to Jackie, who was going to talk about impact.
And we're nearing the very end of the presentation because, as I said, we are keen to hear your comments and questions. But you'll have got a flavour from that part of the presentation already that what we were trying to do in this book was to give quite a comprehensive overview of all of the different aspects of climate litigation occurring in the Global South as a framework for scholarship as it goes forward. The second to last chapter of the book engages in an exercise of thinking about what the impact of the cases that have been decided already might be. And we don't do a full assessment of impact because we recognise that many of the cases are actually very recent standing, and generally it takes 5, if not 10 years or more decades to really begin to see how cases are shaping governance, legal and behavioural outcomes. But we wanted to get at least a sense of whether the cases were beginning to show direct impacts in terms of changing laws, changing behaviours, changing policies, or indirect impacts in terms of the way they might be shaping changes in the attitudes of key actors, and whether those impacts could be described as material, they're sort of tangible changes in the conduct of groups and individuals that you can link to the case, or more symbolic in the sense of changes in ideas, perceptions, and collective social constructs. And we drew particularly on the work of Cesar Rodriguez in coming up with this kind of assessment framework. So that part of the book does look at cases like the South African case of Earthlife and tracks through some of the developments since that case, along with Leghari and some of the other higher profile cases where we do have some sense of what happened afterwards. The very final part of the book, which is very much an exercise in putting our finger to the wind and trying to imagine what might be the future areas for development in this area of case law, is to think about where we saw seeds potentially emerging that might grow into trees and forests and fruit later on. And these were our suggestions in that regard. One was that we hadn't actually seen, despite our expectations, a lot of cases in the Global South docket on adaptation and seeking compensation for loss and damage. But given the extent of the adaptation challenges and the extent of climate harms being felt, particularly in many Global South countries, we expect that this is a phenomenon that will develop over time, and we'll see more of these cases. One of the limitations might be that litigants are hesitant to sue their own governments on adaptation grounds, but it may be a basis for more transnational cases or international cases similar to the kinds of claims we're seeing to some extent at the international level at the moment, before the ICJ and before the IDLOS Tribunal, where Global South countries are making arguments about the responsibilities largely of the Global North for dealing with the effects of climate change. Another area where we see as a potential for future development is cases involving Indigenous peoples. Again, a group of actors often on the front line of climate harms. There were a few cases in the Global South docket that involved Indigenous groups, probably not as many as we'd expect, but we are seeing a trend in several Global North countries of more cases being brought by Indigenous peoples, particularly on human rights grounds. So we'd expect that trend also to take off in the Global South. Similarly, a trend that we've seen in the Global North is more cases of corporate climate litigation seeking accountability of corporate actors for the harms that climate change causes. This hasn't happened as yet, as far as we're aware, in Global South countries, but we think that there is regulatory development emerging that could found that kind of litigation as well across the Global South. And finally, we think that there's plenty of potential for more transnational cases, those kinds of cases where the litigation is actually brought in a Global North jurisdiction, but because a particular government or corporate actor is domiciled in that jurisdiction, but is the basis of the action is really the damage or harms or emissions that are occurring from a particular project in a global south country. So there are our predictions for the future, and we'd really invite people to test us and challenge us and give us examples of whether you agree or disagree on some of those. But we will stop there, and thank you very much for your attention. We look forward to the question.
Thank you so much for that really interesting presentation. Very insightful and interesting to see how Africa compares with the rest of the global south. I'm going to open opportunity to ask questions. Just a reminder, you can post your question in the chat or raise your hand. Perhaps I might kick off with the question to get things going. I completely agree with your statement that, the success of climate litigation or even the numbers surrounding it in the global south depends on an existing legal framework, but also a receptive judiciary. And I was wondering whether in your research you noted an area where the judiciary is either activist or plays a particularly, or not plays a role, but was quite ambitious in delivering their judgments or interpreting government responsibilities.
Want to take that question? Thank you very much, Angela, for that question. Judges and lawyers are generally quite a conservative group of people. The law moves relatively slowly, is always responsive backwards, and judges are often very hesitant and very careful not to be considered to be acting outside their constitutional roles. In fact, one of the big questions which has one of the big issues that has arisen in quite a bit of the climate litigation, both in global north and global south, is whether it is right for judges to be hearing these cases, because these cases raise polycentric, policy-laden arguments. Having said that, if I were to point to a number of judges who have been quite supportive of the fact that the law has a role to play to advance climate justice, and judges can play a role in that while staying within their constitutional remit. Example would be the Pakistani judge Mansoor Ali Shah. Judge Mansoor Ali Shah has written both judicially and extrajudicially about how good lawmaking and good decision making by judges it requires being climate informed and climate consciousness. And perhaps maybe Jackie could speak a little bit more about from the Australian context. We have Justice Brian Preston, who has also adopted a similar attitude.
Yeah, so I'd just say that I think that we see variation across jurisdictions, global north and global south, in terms of the receptiveness of courts to these issues. In my own jurisdiction of Australia, a lot of courts have often been quite conservative in recent cases and focused on questions of justiciability and political political doctrine in a US context. However, what we did observe was that some of the most innovative remedies were often being shaped in cases coming before global south courts, and in particular those countries that have a tradition of sometimes called judicial activism or progressive judicial decision making, particularly in public interest litigation. A number of the South Asian countries and the Philippines, you also saw that tradition then carried through in the climate area.
Thank you. Yeah, it's fascinating. I guess because I am in South Africa, I often look at South African cases, and it shook the academic and legal community in the Deadly Air case, where a High Court judge said that our constitutional environmental right is immediately realizable. And it was an air quality case, but also very relevant, of course, for climate change. But all right, there are two other questions in the chat. So the one question is whether there are any other environmental cases that have been filed between two countries after the trial smelter case. And then another question, do you want to answer that or should I read some of the a few of the questions?
I'm just seeing them come up in the chat that's on the screen here, and there's quite a few that have now started to come through. Just obviously there are large numbers of cases, or well, not large numbers, but there are a significant number of cases now that are being brought between countries, some of which are transboundary air pollution cases or other kinds of transboundary environmental harm cases like the trail smelter case. We classify that as international climate litigation rather than domestic or global south climate litigation. But what is interesting in that area is that more and more of those cases are being brought between countries that are each global south countries, so developing countries bringing cases against other developing countries, often over issues around use of natural resources like water resources, rivers and so on. So that is definitely a trend in the international case law. I don't know, Angela, if you want us to answer the questions in order.
Yes. So you can take it in any order, and you can let me know if you want me to read the question out for everyone to hear, or how do you want to approach?
I think that might be better because otherwise they might not know what we're reading on the screen.
Exactly. All right. So the next question is from Alan at Natural Justice, and he asks, what do you think about the recent ITLOS advisory opinion, as well as the UN General Assembly's recognition to a right to clean and healthy environment? Do you think that this will influence courts to play a more progressive role in determining cases?
Do you want to take that one?
Sure. Thank you for the question. And the short answer is hopefully yes. The very purpose of filing these requests for advisory opinions at both ATLAS and the ICJ is precisely to create more clarity around state obligations to address climate change. And together with the existing international legal materials, including Paris Agreement and international law principles, the hope is that it will influence or it will be used by domestic and regional courts to generate jurisprudence that will help I guess raise the ambition of state action on climate change. So that would be my short answer on that.
And just to add briefly to that, I think what we've seen in a number of global south countries is because there's not that tradition of climate litigation already in some of these jurisdictions, and an openness to using international environmental law principles to inform domestic decision making, that those courts may in fact be more open to using those outside resources, the international case law, the UN General Assembly resolution, to help inform their understanding of how the domestic law applies. So I think that's actually you could see much more progressive cases in the global south in that regard than in a lot of the global north jurisdictions.
All right, I'm going to give two questions. So one is about rights of nature and one is more related to biodiversity conservation. So the one question is, besides Ecuador, do you see a stagnation of the formally rising rights of nature-based litigation? And does that link to climate change? And then the other one is, are there cases related to the impact of climate change on forest or biodiversity conservation?
That's an interesting one. Okay, I can take that question. Thank you very much for those questions. On rights of nature, in fact, in all the cases that we considered in the Global South docket, none of them, apart from the Colombian youth case, relied on rights of nature. And I wonder if it's because by the time the cases were heard, standing was already established, and so the rights of the rights in order to establish standing was no longer a matter for litigation. So that's one thing. As to whether there's a stagnation, I'm not sure about that. That's actually a really interesting point. So I'll definitely look forward to learning more about that. On forests and biodiversity. So this is really interesting because I think that in recent times, there's a real concern that we should not be working in silos, climate change, marine environment, and then not really looking at nature and biodiversity in a much more holistic way. Many of the climate cases involve forestry. So, for example, in many of the cases that were brought by regulatory agencies, the cases were brought against defendant companies for violating forestry laws. There's the examples would be for the Amazon as well as Indonesia and Indonesia and Brazil. There are also forestry-related cases when they deal with indigenous rights, when the indigenous peoples are bringing these cases because the forests have been their homes are in the forest, and these have been affected by proposed climate measures.
Thank you. I'm going to give two questions again. So one is, what formal areas of law have been shifted or developed by climate litigation in the Global South, thinking, for instance, about liability for damages? And then there's a question about how you define climate cases, specifically with reference to India, where there hasn't been a single case where climate change was directly litigated.
So I'm happy to take those. So maybe if I take the definitional question first, that's absolutely right in relation to our analysis of cases coming through in India as well. So this points to the broader definition of climate litigation that we took in the book, which encompassed what we called peripheral cases. So one where climate change was one of many issues that were informing the litigation. So it was not about climate litigation solely, but encompassing climate change as part of a range of arguments, often around air pollution or nature conservation, biodiversity protection kind of issues. And that was a core part of the argument of the book, that in Global South countries, there's not the sort of single issue focus on climate change that you might see in parts of the Global North. And hence, to give a better representation of that case law, we needed to widen our lens, which is why we were able to pick up these cases in many other jurisdictions. In terms of the areas of law that have shifted or developed by climate change litigation, I think one of the key areas that's really been developed and contributed to by Global South climate litigation has been in the context of rights-based litigation, and understanding climate change and climate change protection as fundamental to the realisation of human rights and constitutional rights. And that's a really important contribution that's come through directly from this litigation. Another area has been in relation to environmental impact assessment and understanding that climate change can fit within broader environmental impact assessment and natural resource protection laws that speak generally about the environment but don't specifically talk to climate change. So broadening out the scope of those laws in a way that gives credence and helps develop ideas of what sustainable development might actually mean in practice. In terms of liability for damages, that's an area we're not really seeing as yet, but one that we forecast as a future area for development in terms of the kinds of cases that might emerge in Global South countries in the future, and where we see them playing a leadership role in developing areas of law.
Thank you. It's so nice to hear someone mention the Global South as playing a leadership role. There are questions that are related. So the one is whether you've seen any cross-fertilization of ideas between judgments within the Global South and the Global North. And then a related question was, what level of court engagement with international law have you noticed in the Global South? Are the patterns that have emerged different from in the Global North?
That's one for you.
Okay. Okay. So I'll take that question. Cross-fertilization of judgments, that's actually a really interesting issue. We didn't we didn't see a lot of what we call judicial dialogue where judges are referring to similar cases abroad, unless they are very, very high profile cases which are very well known. And there are two interesting things I would share as reflections. So in a set of interviews that I did with NGOs and civil society actors in Latin America who were bringing cases, I think in Argentina, um, what was interesting was that in the submissions to the court, there would be a lot of examples and relevant cases would be cited from around the world to help bolster the argument that this is a well-established area of law. But the judges chose to ignore all that and would rule on a very narrow procedural or technical point. And one of the things, and this was a very significant trend, like it was very consistent. And I would hypothesize that it was because the judges preferred to rely on well-trodden domestic law than to go around the world in this exploration of laws which they felt did not help elucidate or the legal reasoning. Yes, we do, and so it's quite peculiar. We see some of that somewhere, but then in some others. In the African context, Earth life is cited every time. It's just like it's most important to cite Earth life in every single proceeding. And so definitely that in terms of an example, very successful cross-fertilization, that's been very significant in the African docket. Level of court engagement, international law. I think it's interesting. It feels like as though it could be down to the individual judge. Some judges tend to be quite happy to cite to international law principles and to the Paris Agreement. The Brazilian Supreme Court, for example, was quite happy to talk about the constitutional significance of the Paris Agreement in the Brazilian legal system. But there are many others where we have many examples too, where the level of court engagement with international law was minimal. So overall, it's a very mixed landscape.
Thank you. Then there's a comment and a question, but they relate to a similar theme, and it's whether you think that mediation may be a more useful tool other than litigation to achieve a positive outcome. Cormac Cullinan, for example, says that in his firm, he sees that there are limited funding, so there's really constraints to go to court.
Look, I think that even though Jolene and I spend a lot of our life talking about litigation, we are very realistic about the limitations of litigation. And in fact, one of the findings in the book is that litigation can be a very high cost strategy and even a dangerous strategy for many environmental NGOs to be bringing in some Global South jurisdictions. So in the sense that environmental defenders may come under attack because they're pursuing litigation claims. So certainly where there are opportunities for mediation, alternative forms of dispute settlement, I think that that's always a preferable pathway to litigation. But we also found that in a lot of the interviews and the reasons why people were interested in bringing litigation was because there were powerful actors involved in terms of governments and corporations who were perpetuating a particular state of affairs, but the courts were one avenue that could be used to get some kind of resolution or ruling in relation to a conflict. So obviously it's going to be hugely dependent depending on the country that you're talking about. But we don't have any kind of idea that litigation is the only tool that can ever be used in these kinds of cases.
Thank you. All right, two more questions. So one is, did you identify any examples or trends of backlash to these cases in terms of retribution of any kind against litigants. And then the other case is from an urban planner. Also, the other question is from an urban planner wondering what people are asking for in terms of adaptation and can the planning profession draw or learn from that?
You can take the first one, you can take the second one. Okay. So thank you very much for that question. We did not we did not set out to follow cases such that we would know whether there would be backlash or retribution as a result of filing of those cases. But when after conducting the interviews, of course, we continued to have dialogues and conversations with many people in the field, especially including those who had filed cases. So two responses to that. One is SLAPP suits, and the other one is the dangers that environmental defenders face, particularly in the Global South. So whenever people talk about SLAPP suits, it's of course a significant risk when you are, engaging in climate litigation. But what we found is that actually SLAPP suits is not really. What I would say is that SLAPP suits isn't really the real danger that many litigants would face in the Global South. In places like Indonesia and the Philippines over the last few years, there has been a significant rise in the disappearances of well-known environmental activists. So I think that there are significant risks of physical retribution when it comes to this area of the law. As for the adaptation question, Jackie will be taking it.
And just to add to the question about backlash in terms of regulatory backlash, I guess because the case law in many Global South countries is very new, we weren't seeing trends as yet in terms of legislation being introduced to try and offset the effects of cases. If anything, the backlash is often that there's a very long delay in issuing the court decision and then implementing it in practice, which obviously depends on resources. In terms of adaptation cases, we didn't see as many of these in the Global South docket as we thought we might. And based on the Australian experience, I had expected a large number of adaptation cases looking at things like planning for coastal change, sea level rise, different water infrastructure to handle greater flooding and so on. There were a smattering of those cases, and what they point to is largely the role of local governments as implementers of measures for adaptation, and that climate change was being taken into account amongst many other factors that led to changing weather conditions or changing climate that might necessitate decisions differently about how areas were planned, and particularly the kind of infrastructure that was put in place in cities or rural areas. So it does have implications for planners and the planning profession, but I think it's still an underexplored area in the Global South docket, at least as we saw in the cases.
Right, we have two more questions in the chat and then a hand raised. So I'll get to the questions in the chat first. So the first one is about if there is no legal framework in a particular country, is there a possibility to sue a government? For example, if there is no protection of atmosphere by policy and domestic legislation. So that's one question. The other question is about support mechanisms that are available and effective to protect ecological indigenous knowledge, thinking about, for instance, the indigenous communities in Namibia and South Africa, and often being sidelined by companies which have a lot of influence and financial resources.
Thank you for that question. I'm just thinking about the last question, support mechanisms to protect indigenous knowledge. I'm not aware of them.
I can have a go if you want to do the first question.
Okay, sure. I'm sorry, Angela, could I just ask you to, the first question is whether what are the pathways for suing a government?
if there's no...
Yes, if there's no legislation, for instance, to protect the atmosphere, or I guess climate legislation.
Okay, so
Those are the preconditions.
well, if there are no specific, the way I'm interpreting the question is that if there is no specific climate change laws, and there are no specific laws against, say, air pollution, what are still the ways to hold a government accountable for for climate inaction? So first, of course, is constitutional law. Many of the cases in the Global South dockets are constitutional challenges, and the case theory is fairly straightforward. The idea that the government's state's failure to take action on climate change amounts to a constitutional infringement of the right to life. Because many countries, most countries have submitted an NDC and under the Paris Agreement. And as part of the submission of an NDC, would have prepared policies on how the country is going to mitigate in order to, achieve some net zero target or to adapt to climate change. That in itself provides the basis for litigation because the government or the state has put forward that it would do this, but has failed to. And the question is whether there is a basis for a constitutional challenge. There are also many other areas of laws that have been used as a basis for, so one, public trust doctrine. The public trust doctrine, the idea that a state holds or protects the natural resources for the benefit of its people and future generations, means that there are obligations. And the public trust doctrine is relatively well-founded across many jurisdictions in the Global South, but interestingly has not been relied upon as extensively as we thought we might have expected.
And just briefly on the question that goes to the mechanisms available to support and protect Indigenous knowledge in civil society, particularly where they're coming up against well-resourced oil and gas companies. I think the answer is that there are still not good protective mechanisms, and this may in fact be deterring litigation, even where there are quite significant climate harming activities going on that affect those communities because of the imbalance of power that's occurring. One trend that we did see happening potentially as an intervening factor in this case is where you can have transnational cases occurring. So this may often be supported by NGOs outside the jurisdiction or funders outside the particular country who provide support, advice, protection and resources for the groups who are facing these bigger oil companies, often headquartered in the global north, to bring cases that hold them to account in those global north courts. But we didn't see a trend of using the local courts to find accountability because the kind of conditions, if you like, for that to occur were not really present in a number of those jurisdictions, particularly in Africa.
Thank you. I'm then going to give the final question to Zunadia Musa.
Thank you so much, Angela. Jolene, Jacqueline, thank you both for a very insightful presentation. I have to say that I've long been following your work, and it's really had a profound impact on my postgrad legal research and writing. So my question today pertains to the modes of litigation that you have posited. For example, the grassroots activist, the hero litigator, the farmer. And I would like to know, have you found any one particular actor from this group as leading behind any of the groundbreaking legal victories in, firstly, the Global North cases, and secondly, the Global South cases? Thank you.
Thank you. Thank you so much for your question, and also really happy to hear that our work has been helpful to your work. So I would say that as the vast majority of the cases, around 80% of them, are being brought by NGOs, which typically fit the grassroots activist mode. So as a grassroots activist, we're really looking at a typical medium-sized to small NGOs, and which typically are quite local in their focus and their actions. But increasingly, we also see that the world of the NGO world is so connected. It's like there we see the boomerang effect where NGOs are reaching out beyond their jurisdiction. We saw that in the case of the EACOP, right, where in East Africa, activist groups and NGOs were reaching out to connect with NGOs in France and in Europe to form a transnational coalition of over 100 NGOs to try to put legal and non-legal not legal and non-legal pressure to stop the project. So I would say that amongst the modes of litigation, the most prominent one or the most impactful one has been grassroots. I should also mention that under the farmer, funders would fit that mode of litigation, and oftentimes as litigation is quite an expensive process, the farmers also work closely with the grassroots activists in order to work together to advance legal strategies. I hope that answers the question.
I'm going to come in again and say, it does answer my question because I used your same analysis, and I applied it to 3 cases in the global north, being the Agenda case, the Milieu Defensie case, the Nobel case. And then I applied it to 3 global south cases, being the Earthlife case, I call it the Shell case, which is the wildlife case, and an ESCOM case, which is a lesser well-known case. And I actually I classified the farmer as being the actor leading behind the most of the victories. And I said this because they sort of seed by funding, by initiating new climate litigation and new strategies. So, but yeah, I see that it does tie in, and thank you very much for that clarification.
Could I just add to that, to respond to that very quickly? That's absolutely in line with our findings. These high-profile cases that you're focused on often involve complex legal strategies that have taken years to develop and to implement. They will not be possible without the farmer. Yeah. So it's in line, I think, and I would be really interested to read your analysis because that sounds really like a fascinating project. Thank you.
Thank you so much, everyone, for attending this webinar and for engaging so well with our speakers. Jolene, Jacqueline, thank you so much for joining us, for making the time. We really cannot wait to read your book and to engage more with your work, and also clearly for other scholars to take it further as well. So thank you again. I hope you have a really lovely evening there. This Zoom was recorded and we will make the recording available as well. Thank you, everyone. Have a great day.
Thank you.
Thank you.
Thank you.
Just